Good morning. Yet another case, judgment, very fantastic judgment, which will help you to understand the criminal trial when the case is rests on circumstantial evidence. Here, this case is AR 2023 Supreme Court 3841. AR 2023 Supreme Court 3841, Kamal versus State, NCT of Delhi. First, let us see the case of the prosecution. On 10th September at about 4:15 p.m., complainant, the brother of the deceased, found his brother lying dead. So, they took both to the hospital and declared dead. Then thereafter, the allegation was against a son of the deceased, and two persons helped him to kill the deceased. The lower court convicted all the three accused under 302 ready with 34 IPC, rest on circumstantial evidence, and imposed a fine of rupees 50,000 also. Appeal was also dismissed. So the High Court, the Supreme Court, while deciding the issue, the PW 21 evidence wherein he has categorically admitted that the two other accused were shown to him at the police station by informing that they have murdered the deceased. So the Supreme Court has held the dark identification. Dark identification means identifying first time before the court is called dark identification. First time identifying the accused before the court is dark identification, because the identification period the accused refused on the ground that they have already shown to the witnesses. Then the question arises. The improvement, the most important area which you have to understand the criminal trial is that they say the PW20 has stated that he informed the police about the description of the accused, that one boy was fair and the other was having wheatish complexion. That they say that since it was not available under 161 statement, this statement is substantial improvement that you have to understand. Then they say the call records, the call records were not properly proved about the location of the incident. Then finally, the one another SIM card was recovered from the accused, but that was not stands in the name of him. Therefore, the failure on the part of investigating officer to prove how this SIM came to the possession of the accused. Therefore, they said, though there were evidences that the accused, the son, seems to have beaten his father earlier, but the court says these circumstances concerned must or should or not may be established. Therefore, unless and until the substantially they proved the evidence with circumstantial evidence, the accused were entitled for acquittal. Therefore, they were acquitted from the charges. And I request my learned friends, senior advocates, my best friends who have started commenting, particularly specifically commenting about the judges' discretionary power. I don't think that is somewhat a good improvement of exhibiting brevity in commenting on judgments. The judgment which they criticized recently is not a new one. and these judgments are old one being followed several times. And for your kind information, the present Surakshik CRPC, Nagarik Suraksha CRPC, being introduced as a bill, also contains the powers to the magistrate while impose conditions directing them to indulge in social activities and social services. This is much my request for my friends. Best wishes.